Do you know what dirty cops love the most? Qualified immunity. They hide behind it, thinking they're untouchable. But you know what scares them to death? Jail. They know they'll get torn apart by the very same people they put behind bars. So, let's dive into 3 cases where these corrupt cops finally got a taste of real justice behind bars. In April 2012, a woman named Susan and her 9-year-old daughter moved into an apartment in Grand Haven, Ottawa County. Little did they know, they were moving in next door to pure evil. Their neighbor was former Muskegon County Airport police officer Theodore Dyer. At first glance, Dyer seemed like an ideal neighbor. He was in his 60s, had a stable relationship, and was a law enforcement officer. Susan couldn't have hoped for a better profile for a neighbor, and quickly built a good relationship with Dyer and his girlfriend. Being next door meant Susan and Dyer ran into each other almost daily, leading to many conversations. But their relationship didn't stop at small talk. Dyer soon became a part of Susan's small family. In an interview with local news, Susan shared her thoughts about the former police officer. "Ever since we moved in, we talked daily. He and his girlfriend never had children, so they adopted my kids, I guess." Unfortunately, Susan's trust in Dyer meant her 9-year-old daughter spent much time at his apartment. Especially when Susan had to work, her daughter often spent time at Dyer's apartment. However, Susan's perfect little world was about to be thrown into complete disarray in a way she could never have imagined. One rest of his life behind bars. In a tragic and perhaps ironic twist, Dyer's life came to an abrupt end in prison sooner than anyone could have anticipated. He began his sentence in January 2014 at the Saginaw Correctional Facility. Life in prison is often harsh for former law enforcement officers who are typically viewed with hostility by other inmates, and it gets worse when they find out what they did. Dyer, being a former police officer convicted of a crime against a child, quickly became a target. The prisoners, many of whom were notorious criminals themselves, were disgusted by his actions. In the prison hierarchy, crimes against children are considered particularly heinous, and Dyer found himself at the bottom of this pecking order. Unfortunately for Dyer, his cellmate Steven Sanderson shared the same disdain. Sanderson was serving a life sentence without the possibility of parole for a murder he committed in 1991. Despite his own violent past, Sanderson could not tolerate Dyer's actions. This mutual animosity led to a fatal confrontation between the two. On October 29, 2014, just 10 months into Dyer's prison sentence, his cellmate Sanderson snapped and killed the former police officer inside their cell. The news of Dyer's death quickly spread through local media channels, stirring mixed emotions among those familiar with his case. One person who found a complex sense of closure was Susan, the mother of Dyer's young victim. While Susan expressed she never wished death upon anyone, she admitted, feeling a measure of relief for her daughter, knowing that Dyer could no longer harm her. Following a swift investigation by the Michigan State Police, Sanderson confessed to detectives that he had killed Dyer. He was formally charged with murder on February 23, 2015. In his court appearance before Chief Circuit Judge Fred L. Borchardt at Saginaw County Circuit Court, Sanderson pleaded guilty to second-degree murder. Inside the courtroom, Sanderson appeared composed and showed no signs of remorse for his actions. When asked by his attorney James Gust if he was responsible for Theodore Dyer's death, Sanderson affirmed without hesitation.
The reason I killed him was because he was a child molester.
You did in fact kill him.
Oh, sure.
And you intended to kill him.
Oh, sure, yes.
Later during the hearing, the judge asked Sanderson to recount how he had killed Theodore Dyer. Calmly, the convicted killer explained to the court the sequence of events that led to Dyer's murder. Sanderson did not attempt to conceal his contempt for Dyer, revealing that he had learned about Dyer's conviction for a heinous child rape case while they were both incarcerated. Sanderson went on to describe how Dyer had provoked him on that fatal night by attempting to justify his despicable actions against a young girl. Unable to tolerate Dyer's justifications any longer, Sanderson admitted that he took matters into his own hands and ended Dyer's life. Sanderson's statement in court was chilling in its straightforwardness, reflecting his deep-seated anger and the intense emotions surrounding the circumstances that led to Dyer's death.
Go ahead and explain to me basically what you told the staff when you came out of the cell.
My bunkie was talking about his crime, what he was in prison for, and children. I didn't appreciate it, so I killed him. Plain and simple.
About what time did this occur?
Late at night, probably about, in between
Silver to 11, where can I
maybe
check?
12 and 2. More closer to 12.
Okay, you got any details you care to add?
No, I just did what I thought was right, That's it.
Okay, did you knock him out, choke him out kind of a deal? Is that what it was?
Yep, I hit him in his face, and then when he fell out, I took his shoelaces out of his shoes and tied them around his neck and
So he was unconscious at the time. Did you use anything to strike him with, or just hit him with your fist?
Just my fist.
Okay. Well, they're probably going to keep you over here in this cell for a little bit. We're going to get you into an observation cell over on the other side.
An observation cell? I'm not suicidal.
No. It's what we got available.
Oh, okay.
Okay. So all I want you to do here is just kind of kick back and chill for a little bit, and we'll get this wrapped up. All right?
No problem with you guys.
Stephen Sanderson explains that he punched Dennis, causing him to fall to the ground. After Dennis was down, Sanderson used shoelaces from his own shoes to choke him. He held the shoelaces tightly around Dennis's neck for a few minutes until he realized Dennis had stopped breathing and was dead. Once Dennis was dead, Sanderson carefully placed his body back into his bunk and covered him with blankets to make it appear as though he was just sleeping. After arranging the scene, Sanderson packed up all his belongings. He chose to wait until the next morning to report Dennis's death, thinking it would be better to avoid causing chaos and panic during the night.
How many times do you think that you punched him?
Maybe once, twice, nothing
Once
more.
or twice? Okay. And then at some point, evidently, you hit him hard enough to knock him down or knock him out. Where do you think that you struck him that time?
Probably caught him on a good shot on the chin.
On the chin. Okay. So he went down and now he's on the floor. Do you recall how he was laying on the floor? Side, back, face up, face down?
I don't recall.
Okay. And then you said that you choked him out, I believe. Is that
No, I didn't choke him out. When he
Not
went
when he was
down,
on-
I
not
took
when he
the
was down.
shoelaces out of his shoes,
okay?
and I made a decision that this was going to end now. So
Okay. So I guess then I must have just misunderstood you. I thought you said that after you punched him, he was down, that you choked him prior to using the shoelaces.
no, I just took the shoelaces out and
Okay.
wrapped
And they
them around.
were out of his shoes? Okay, so you took the shoelaces out. Obviously, you wrapped them around his neck.
Just once. Wrapped them
once.
around my hands. Tied them two together.
Okay.
There were two shoelaces, so
Two
I
shoelaces.
tied the ends to ends together.
Okay.
Wrapped it around the hand, put it around his neck, and held it.
Okay. How long do you think you had to hold it before you were confident that he was?
Actually, a long time.
Long time being minute, 2 minutes, 5 minutes?
I don't know, but it just seemed like a long time.
Okay. I imagine that probably your time recollection then would probably not be accurate, or because I'm sure
It
that you
seemed
were
like a
probably
long time.
a little tense, a little hyped, had the adrenaline going. So you end up, you're confident that he is now deceased. You pick him up and you said you put him back in his bunk.
Put him in the bed and faced him towards the wall so that it looked like he was sleeping.
So he was sleeping. Covered him up.
Covered him up.
Okay.
Stephen Sanderson also explained that he didn't plan to kill him but used the shoelaces that were conveniently available. He believes that strangulation is a more personal way of killing someone compared to using a gun. Sanderson had initially intended to request a transfer to a different cell in the morning, but his cellmate's actions led him to change his mind. He admits to being a repeat offender, but feels that some people do not belong in society and should remain in prison. Sanderson has a history of being straightforward and honest about his actions, and has never tried to deceive anyone regarding past altercations.
We just need to know your mindset at the time.
I just,
So the shoelaces happened to be there, and they were convenient. So they were an item of convenience.
yes.
It wasn't something that you had determined prior that I'm going to knock him down, I'm going to take the shoelaces, I'm going to kill him. It just
Right.
Seemed like it was like, hey, he's knocked out now. There's the shoelaces, and now I'm going to kill him.
Well, that's how I committed my other murder.
It was kind of a spur of the moment type
No,
thing.
strangulation.
Oh, okay.
I just don't think stabbing or shooting somebody is a little too impersonal. If you're going to kill somebody, you might as well be personal about it, right?
You think that's more personal?
Yeah, I just, I know it sounds kind of crazy, but if you have to go to that extent,
Yeah.
I want it to be personal. I don't like violence, but if I have to go to that extent, then I want it to be personal.
Okay.
so obviously you comparing strangulation to stabbing or shooting, that the strangulation is more personal.
Yeah.
Obviously, a gun, you can shoot somebody from many feet away or whatever.
Yeah.
So, okay.
I mean, it's like war. If you're going to go to war, there's no rules. I mean, not in my mind.
You're aware, I think you mentioned earlier, that you were going to try to not lock with him anymore. You're
Yeah,
going to bring it up.
When he first started talking, that's the first thing I did. I told him, shut the fuck up. I'm going to one of us is getting moved tomorrow. So that was my initial plan, to just go to McLean and say, get this fucker out of here. Because I had been locking with him for 2 months and I didn't know any of this.
Yeah.
Apparently everybody else knew it, but I didn't. And they, failed to tell me anything.
So it's an option, but then he just pushed it too far. And
Yeah, and he just kept going with it.
Although Sanderson remained steadfast in his lack of remorse for taking Dyer's life, he made it clear that he did not welcome the hero worship from those who believed Dyer deserved to die for his crime of child rape. During his sentencing on April 22, 2015, Sanderson asserted that he did not consider himself a hero. Sanderson also addressed those who had criticized him for his actions in the months leading up to his sentencing. His parting words indicated that he was unmoved by public opinion and stood by his decision to end Dyer's life, despite the controversy it had stirred.
I know God is the only judge we have. I've just set the appointment up. So I don't feel bad for what I did, I feel bad for maybe his family or something.
Some of Dyer's family members attended the court proceedings and listened to Sanderson's statements. However, they chose not to address the court or speak to the Saginaw News after the sentencing. Judge Fred L. Borchardt imposed the harshest penalty possible on Steven Sanderson: life imprisonment with the possibility of parole. Sanderson, now serving 2 life sentences, was transferred to a more secure custody level by the Michigan Department of Corrections personnel. He is currently housed at the Ionia Correctional Facility, the highest security level facility in the state. If you think Dyer was a horrible human being, wait until you hear about Deputy Gerard John Schaefer. But before we move on, smash that like button. Unlike Dyer, who was a convicted sex offender, Gerard John Schaefer was a predatory serial killer infamous for preying on teenage girls and young women. He was known by several chilling names such as the Hangman, the Killer Cop, and the Butcher of Blind Creek. Schaefer's crimes were horrific and spanned over many years. In 1972, Schaefer was convicted of the murder and mutilation of 2 teenage girls in Port St. Lucie, Florida. Authorities suspect he may have been responsible for the deaths of as many as 26 other female victims. His nickname, the Killer Cop, stemmed from his role as a sheriff's deputy in Martin County, Florida, at the time of his initial arrest. Schaefer was notorious for his sickening way of doing things. They called him the Hangman, because he would tie up his female victims to trees, slip a noose around their necks, and put them through hell before finally snuffing out their lives in the most twisted ways imaginable. Schaefer's depravity didn't stop with the murders. He also engaged in heinous acts on his victims' bodies, including dismemberment, cannibalism, and necrophilia. These shocking details, though horrifying, are documented in the history of his killing spree, which is believed to have terrorized Florida for over half a decade. But the drama and media frenzy that followed his arrest went beyond imagination, unearthing shocking revelations that rocked the entire nation. But what in the world could drive a cop to become a sick, sex-crazed serial killer like Gerard John Schaefer? To get it, we've got to dig into Schaefer's messed up childhood, where you start to see the twisted path he ended up on. Born in Neenah, Wisconsin, On March 24, 1946, he was the eldest of 3 children. His father was a traveling salesman, which meant Schaefer's early years were spent moving between states before the family settled permanently in Fort Lauderdale, Florida in 1960. Despite being the firstborn son, Schaefer had a strained relationship with his father, who he felt was overly critical and favored his younger sister Sarah over him and his brothers. Seeking solace or perhaps validation, Schaefer began cross-dressing at the young age of 12, wearing women's clothing and underwear. This early divergence from societal norms may have been a manifestation of deeper psychological issues that would later contribute to his violent and aberrant behavior. He quickly became interested in acts of self-bondage, where he would strap himself to a tree and cause multiple injuries to himself. After playing some of these old games, Schaefer subsequently admitted to a psychiatrist that he had extreme self-loathing. In his words, "I always got killed in the games I wanted to die. When I was younger, my father loved my sister more than me. Therefore, I wanted to be a girl because I was such a disappointment to him. Because I couldn't win his approval, I played games where I wanted to die." As Schaefer grew older, self-harm was no longer enough to quell his sexual cravings, so he soon started having fantasies about harming other people, specifically women. In fact, when Schaefer was a young student in a Florida high school, he confided in his writing teacher, semi-famous Southern novelist Harry Crews, that the teenager's confessions had disturbed him with murderous thoughts. When Schaefer spoke with the therapist after Crews had referred him, the young man made even more shocking disclosures. He admitted to his therapist, "I would like to kill things. I even like to shoot at cows." He went further, disturbingly revealing that he had decapitated animals with a machete and then engaged in acts of sodomy on their remains. Several years later, Schaefer's twisted fantasies became a horrifying reality. In 1972, while serving as a deputy with the Martin County Sheriff's Department, he committed his first known murders. This marked the beginning of a series of heinous crimes that would eventually expose him as a sadistic serial killer. Before his law enforcement career in Martin County, Schaefer had been dismissed from the Wilton Manors Police Department as a patrolman. His superiors discovered he had been using his position to target and gather personal information on female motorists, whom he later contacted for dates. This unethical behavior led to his termination. Earlier, in 1969, he had also been fired from a teaching position due to completely inappropriate conduct. Despite these dismissals, Schaefer's ability to manipulate and deceive allowed him to secure another law enforcement position. He forged a letter of recommendation from Wilton Manors to support his application, demonstrating his cunning and determination to continue his predatory activities within the ranks of law enforcement. Schaefer, having shown himself to be too intelligent for the system, got himself into a position where he could take full advantage of the faith that people placed in law enforcement to fulfill his darkest fantasies about sex. On July 22, 1972, at around 2 in the morning, he abducted 2 teenage hitchhikers, Nancy Ellen Trotter, 18, and Policy Wells, 17, whom he had met the day before. He took them to a wooded area and tied their necks to a noose, telling the girls he would rape, kill, or even sell them into prostitution. Fortunately for the women, Schaefer received a dispatch call informing him to report immediately to the police station. Schaefer quickly abandoned the girls in the woods, but not before warning them not to try to flee, knowing that they would undoubtedly die as he had promised. The 2 girls were able to break free and made their way to the closest police station, which was Schaefer's precinct, where they were telling the story of their horrifying experience. When Schaefer got to the woods, he realized he had made a terrible mistake, and the girls had fled. After his failed attempt to frighten Nancy Ellen Trotter and Paula Wells, Gerard John Schaefer hurried home and reluctantly called Sheriff Robert Crowder to confess to his reckless actions. In a desperate bid to alter the narrative, he concocted a fabricated story, claiming he had intended to scare the girls to demonstrate the dangers of hitchhiking. Given the extreme lengths he had gone to, few believed his account. Consequently, Schaefer was promptly dismissed from the police force and taken into custody. Sheriff Crowder directed his officers to charge Schaefer with false imprisonment and assault. Despite his serious offenses, Schaefer managed to secure his release about 2 weeks later after posting a $15,000 bail. One might have expected this close call and his upcoming trial in November 1972 to encourage Schaefer to turn over a new leaf. However, like many serial killers, he couldn't resist his dark impulses. After a brief period of lying low, Schaefer resumed his deadly activities with even greater precision. On September 27, 1972, he abducted and brutally murdered 2 teenage friends, Susan Carol Place, 17, and Georgia Marie Jessup, 16. Similar to his earlier failed attempt, Schaefer tied Place and Jessup to a tree, subjected them to torture, shot them in the mouth, and gruesomely hacked them to death. This marked another tragic chapter in Schaefer's reign of terror, demonstrating his escalating brutality and disregard for human life. Afterward, he buried their remains on Hutchinson Island. However, in an interview while incarcerated, Schaefer denied abusing the girls, saying he had only wanted to scare them.
Oh yeah, ha 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 ha. You think it's so funny? Well, we'll just tie you over here to this tree, and we'll tie you over to this tree, and I'll leave and I'll bring somebody back and sell you. Well, I didn't. I tied them to the tree, but I didn't go and get anybody and sell them. I just wanted to give them a scare. And of course that was wrong. I shouldn't have done that. I was trying to impress on them the dangerousness of their situation, running around. They were nice kids, you know. I didn't want to see them end up in a ditch. And I was wrong, and I paid the price. And I pleaded guilty. I felt guilty. I gave them each a written apology. What else can I do, you know?
Gerard John Schaefer recalls an interrogation where he was accused of killing 34 women. He went in expecting medical help, but was instead met with accusations from the state attorney's office. Realizing their intentions, he gave them made-up stories that had nothing to do with any murders. As punishment, he was put in solitary confinement for 2 weeks to break him mentally. In 1981, Schaefer received the names of the alleged victims and contacted authorities to clear his name. The FBI and local law enforcement eventually exonerated him, finding no evidence linking him to any crime scenes. Despite being falsely accused of necrophilia in a newspaper article, Schaefer maintained his innocence and demanded proof of the allegations.
Well, I walked in the door, and I went to see the intake doctor, whoever it was, and he says, oh, you're the guy who killed the 34 women. How do you feel about that? I thought, wow, you know, this isn't a situation where I'm going up to find out. This is a situation where it's going to be an interrogation, and they're going to, whatever I say is, this is not going to be for medical purposes at all. This is like talking to the state attorney's office. The worst thing he could have possibly done was say that, because then I said to myself, well, they want stories? I'll give them stories. Oh, I gave them lots of stories. Nothing had to do with any murders. Told them everything I could think of and went and talked to the bugs on the wing and tried to find some more stories to tell them. I told them all kinds of stories. But nothing that implicated me in any crimes. I certainly not implicated myself in any murders. I had the presence of mind to understand what they were up to. And then, the same day, they threw me in solitary confinement, unbelievable filth on the floor, and I was held for 2 weeks in the most incredible dungeon that you had ever imagined, with lunatics, drooling fucking lunatics. Well, I realized later that this was in order to break me down, to destroy me, you know, mentally, to bring me to my knees, and to make me malleable, that I would say and do whatever they wanted me to do. Having been through the system one time, you realize the tricks of their trade that they use to break people. And that's what they were doing to me. They weren't interested in whether I had blackouts. They wanted me to make an inculpatory statement. And I didn't have anything to say. I didn't kill anybody. Especially, and I said, well, who are these 34 people? I said, well, we don't have to give you the names. I said, well, yeah, ooh. I think if you're going to accuse me of killing 34 people, I'd like to have some names and some dates and some MOs and things like that.
He also talks about his interactions with other convicted serial killers, like Ted Bundy and Bernard Giles. Schaefer notes that while they might deny their crimes officially, they often admit guilt to psychologists, writers, or each other. He mentions Otto Adelman, accusing him of lying about their alleged partnership in killing over 100 people. Schaefer expresses contentment with living in prison and has no desire to return to society, citing stress and lack of resources as reasons. He challenges authorities to provide concrete evidence linking him to any crimes, offering to take polygraph tests and cooperate with investigations. Schaefer insists that the evidence against him is false and that he is a regular person, not a super-intelligent serial killer like Ted Bundy. He also discusses the case of the purse with bullets, which was allegedly stolen from his home and used as evidence in one of his cases. Over the next few months, Schaefer went on a killing spree, taking the lives of several young women in a manner consistent with his usual style. The majority of the victims were teenage girls who had vanished. Schaefer accepted a plea deal for 1 count of aggravated assault, which resulted in a 1-year jail sentence with the possibility of parole after 6 months. Little more than 4 months into his sentencing, the remains of Susan Place and Georgia Jessup were discovered by a father and son who were gathering guarded aluminum cans in a wooded area in Oak Hammock Park, Port St. Lucie, Florida. Forensic examination of the badly decomposed remains of Susan Carroll Place and Georgia Marie Jessup provided harrowing details of the horrific suffering they endured at the hands of their killer. Even after their deaths, Gerard John Schaefer continued his despicable crimes by decapitating their bodies and keeping some of their body parts as trophies. The gravesite where their remains were found was shockingly close, just 6 miles away from where Schaefer had abducted Place and Jessup in July of the previous year. This crucial piece of information, coupled with the striking similarities in the abduction and murder methods to Schaefer's earlier attempt with Nancy Ellen Trotter and Paula Wells, prompted police to obtain a search warrant for his home, vehicle, and his mother's house. During the search of Schaefer's mother's house, investigators unearthed a wealth of incriminating evidence, particularly in his bedroom. Among the findings were personal mementos, a dress book, a gold tooth, and clothing belonging to other confirmed murder victims and women reported missing in the area. Shockingly, police also discovered teeth and bone fragments that were forensically linked to at least 8 additional victims. Perhaps the most chilling discovery was the collection of 300 pages of crude murder stories authored by Gerard John Schaefer. These writings, both typed and handwritten over the years, detailed the rape, torture, and murder of numerous women. They provided a disturbing glimpse into the depraved mind of a serial killer who derived pleasure from inflicting immense pain on his victims. Ultimately, these findings played a pivotal role in Schaefer's prosecution, serving as crucial evidence to illustrate the depth of his cruelty and the calculated nature of his crimes. The discovery of the writings highlighted his premeditated and methodical approach to committing heinous acts of violence against innocent victims. In Schaefer's home, where he lived with his then-wife Teresa Dean, the police stumbled upon a critical find, a distinctive suede purse that belonged to Georgia Marie Jessup. Teresa Dean confirmed that Schaefer had given her the purse back in November of the previous year. However, things took a dark twist when Schaefer was locked up shortly after the bodies of Susan Carroll Place and Georgia Marie Jessup were discovered. From prison, he frantically called his wife, urging her to get rid of the purse. Little did he know, it was already too late. In October 1973, Gerard John Schaefer faced official charges for the murders of Susan Place and Georgia Jessup. Despite overwhelming evidence against him, Schaefer maintained his innocence defiantly throughout the trial. However, his facade did not fool anyone, and he was ultimately convicted for both murders. The court sentenced him to 2 life sentences, ensuring that he would spend the remainder of his life behind bars. Although Gerard John Schaefer was never tried for many of his suspected crimes, the discoveries from the search of his home fueled speculation and sensationalism in the media. Conflicting reports and hyperbole surrounded the extent of his murderous rampage, with police suggesting he may have been responsible for over 30 murders. The handwritten stories found in Schaefer's possession, originally dismissed by him as fantasies, were seen by law enforcement as potential narratives of real crimes. This perception led investigators to believe that Schaefer's crimes extended far beyond those for which he was convicted. Detective Dave Kelly, who extensively interrogated Schaefer, described him as a sexual psychopath and expressed a strong belief that Schaefer had committed numerous additional crimes. Kelly stated, "I strongly believe Schaefer was responsible for a lot more crimes than he was confined for. The first crime attributed to him dates back to 1968, but I suspect he started his activities much earlier, possibly in his early teens. Murder, not just his sexual activities." This perspective highlights the grim reality of Schaefer's depravity, hinting that the true extent of his atrocities may never be fully known. Despite facing life imprisonment, Gerard John Schaefer shamelessly basked in the media attention his case garnered. He continued to vehemently deny his guilt, but capitalized on his notoriety by publishing 2 books, Killer Fiction and Beyond Killer Fiction, with the assistance of his ex-girlfriend, Sandra London. Many speculated that these books were based on true accounts of his gruesome killings, but Schaefer maintained they were purely fictional. Behind prison walls, Schaefer boasted about his crimes in letters to London, claiming responsibility for multiple murders, and even boasting that he was one of the top serial killers of the century. However, his relationship with London soured dramatically after she publicly labeled him a serial killer during an interview. Enraged by her remarks, Schaefer attempted to sue her and threatened her with repercussions from his criminal connections outside prison. Despite his threats, London obtained a protective order against him. Amidst the external drama, Schaefer faced a bleak existence in prison. Reports surfaced that he cooperated with authorities, allegedly providing information on fellow inmates in exchange for favors. This behavior further highlighted his manipulative and self-serving nature, even as he continued to assert his innocence in the face of overwhelming evidence against him. After serving 22 years of his life sentence, Gerard John Schaefer, then 49 years old, met a brutal end on December 3, 1995, when he was found stabbed to death in his prison cell. Faustino Rivera, a convicted murderer, was charged with the violent killing, during which he slit Schaefer's throat and stabbed him 42 times across his face, head, neck, and body. Rivera did not provide a motive for the act, but it is widely believed to have been retaliation for Schaefer's alleged role as an informant against a powerful inmate. Schaefer had been a deeply unpopular figure in prison, facing frequent attacks from other inmates, including incidents where he was targeted with feces and his cell was set on fire twice. Even the guards had little sympathy for him. The news of his death elicited various reactions, but Judge Cyrus Trowbridge, who had presided over Schaefer's trial, captured the prevailing sentiment succinctly. Reflecting on Schaefer's demise, Judge Trowbridge remarked, "He's finally gotten the death sentence he ultimately deserved but couldn't be given." Now, let's turn to our final case and see how an ex-military officer turned Brazilian gangster ended up accused of at least 50 murders. Floresvaldo de Oliveira, better known as Cabo Bruno, rose to infamy in Brazil during the early 1980s by assembling a ruthless death squad that terrorized the outskirts of Sao Paulo. Motivated purely by greed, Cabo Bruno's gang operated with brutal efficiency, resembling bloodthirsty bandits who killed scores of people and extorted merchants in Brazil's largest city. Their reign of terror spanned from 1982 to 1983, a period marked by heightened crime across Brazil. The 1980s in Brazil were tumultuous, with widespread crime exacerbated by a repressive military dictatorship and rampant gang violence within corrupt police forces. Amid this chaos, Cabo Bruno emerged as a singular figure, not quite like other criminals or gang leaders of the time. Born in Ochoa, Brazil, on November 18, 1958, Cabo Bruno acquired his moniker during childhood in Catanduva, where friends playfully likened him to a local drunk named Bruno. The nickname stuck so firmly that even his mother adopted it. For many boys from impoverished backgrounds like Cabo Bruno's, the options seemed limited to joining criminal gangs or enrolling in the police force as a means to escape poverty. Cabo Bruno's career path led him to join the military police of Sao Paulo state during a time when law enforcement was deeply intertwined with criminal organizations and death squads. The distinction between police officers and criminals is often blurred, evident only in their uniforms. Despite his initial role, Cabo Bruno's ambitions for power took a sinister turn, transforming him into a vigilante serial killer who exercised life-and-death judgments without remorse. Numerous victim accounts painted a chilling portrait of Cabo Bruno's methods. Some executions reportedly stemmed purely from arbitrary reasons, such as disliking a tattoo or a perceived association with criminality. This behavior was confirmed by police investigations, highlighting a case where Cabo Bruno killed a young man simply because of a small cross tattooed on his wrist. In his eyes, any tattoo hinted at criminality and warranted summary execution. Money became Cabo Bruno's primary motivation, driving his activities outside official duties. He organized a death squad that operated predominantly in the district of Jabaquara, targeting unarmed civilians and extorting traders through violent means. The squad unleashed terror akin to crazed maniacs, firing upon innocent civilians and coercing traders into surrendering their money to avoid harm. During 1982, a period marked by frequent violence and fear in Sao Paulo, Cabo Bruno orchestrated a wave of killings that terrorized the local population, leaving bullet-ridden bodies strewn across the streets on a near-daily basis. Despite the audacity of his crimes, Cabo Bruno was not without cunning in evading capture. He employed a strategy of using 3 different types of cars, a Chevrolet Impala, Ford Maverick, and Chevrolet Chevette, all of which he regularly repainted. This tactic ensured that his gang could carry out surprise attacks during their raids, enhancing their operational effectiveness and maintaining an element of unpredictability. Cabo Bruno's reputation and operational impunity were bolstered by his connections to high-ranking officials, who provided him with protection from law enforcement scrutiny throughout 1982. This alliance shielded his criminal enterprise from investigation and allowed his vigilante group to continue their violent activities without interference. However, the downfall of Cabo Bruno and his gang began when one of his victims, José Aparosito Benedito, miraculously survived a shooting. Despite sustaining severe injuries, Benedito feigned death until the assailants departed, then managed to escape and reach the authorities. Benedito's testimony and identification of Cabo Bruno led to a heightened focus on apprehending the vigilante leader. This pivotal moment eventually unraveled Cabo Bruno's criminal operations and brought him to justice, ending his reign of terror over Sao Paulo's outskirts. Cabo Bruno's arrest in September 1983 marked a turning point in his reign of terror. The police investigation revealed shocking details about his gang, which included at least 12 police officers, among them a captain and a lieutenant. Accused of orchestrating the deaths of over 20 individuals, Cabo Bruno faced a formidable legal battle. Witnesses came forward, recounting seeing him commit these heinous acts, which, corroborated by credible evidence, formed a compelling case against him. Despite his admission to only one murder, the weight of witness testimonies and forensic evidence left little room for his defense. After enduring 12 trials, Cabo Bruno received a staggering sentence of 113 years in prison. However, even behind bars, his notoriety persisted. He managed to escape from prison on 3 separate occasions, with the third and final attempt occurring on May 30th, 1991. At some point during his imprisonment, Cabo Bruno was transferred to the Jose Augusto Cesar Salgado Penitentiary in Tremembe. There, he found solace in Christianity and began to reshape his life. He later converted to evangelical Christianity and renounced the name Bruno, which he felt was tied to his criminal past. While in prison, he also discovered a passion for art. In 1998, an exhibition featuring his artworks was held in Sao Paulo. 10 years later, Cabo Bruno experienced a remarkable transformation when he married a housewife who volunteered at the prison. By then, he had become a pastor at the prison chapel, embracing a new lease on life. During his trials, Cabo Bruno admitted to killing 20 people, but claimed others had committed more murders while using his name. This partly explained police allegations that he was responsible for over 50 deaths. Cabo Bruno's journey appeared to reflect a biblical transformation when he was granted freedom by the Taubaté court on August 22, 2012. Despite serving less than 30 years of his sentence, the court cited his good behavior and decades spent in prison as grounds for release. He joyfully joked about carrying his release papers to avoid being mistaken for an escapee. However, his newfound happiness was short-lived. Just a month later, on September 26, 2012, Cabo Bruno was tragically murdered while driving with his family in Pindamonhangaba's Quadra Coberta neighborhood. After attending a church service in Aparecida, 2 men ambushed his vehicle and fatally shot him, leaving his body riddled with bullets. Although his relatives escaped harm, Cabo Bruno died at the scene. Police suspected the killing was an execution, suggesting an extrajudicial act. Despite a widespread manhunt, the assailants escaped on foot and were never apprehended. Following Cabo Bruno's death, his family auctioned several of his paintings to start afresh elsewhere. Since then, little has been heard about Cabo Bruno's family, marking a controversial end to the life of a man who almost evaded justice. Abuse of power happens in every field, but it's especially messed up when it happens in law enforcement. Imagine the people who are supposed to protect us turning into the ones who make our lives a living hell. It's a tough pill to swallow, but it happens. So, here are 4 jaw-dropping cases where corrupt cops finally got what was coming to them right there in the courtroom.
If it is your intention to change your plea from not guilty to guilty, then I will take your plea, and certainly you'll have an opportunity to make any statement that you want to make. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
I'm not trying to waste your time.
You are aware that there are 8 clues, correct?
Correct.
One of them is when the suspect can't keep their balance during the instruction phase. Does that ring a bell?
Yes.
You did not exchange any words between yourself and Mr. Fernandez's wife.
If I did, I would have explained the situation to her. I don't recall really any detailed conversation with her.
In Denver, Colorado, Anthony Waller stood in a courtroom, facing the cold reality of a first advisement hearing. This was a standard procedure where a judge explains why a defendant is being held and outlines the steps ahead. Waller hadn't been officially charged yet, but the shadow of serious accusations loomed over him like a storm. Waller was under investigation for a string of offenses. These charges were linked to a disturbing incident at a local motel, where Waller was accused of assaulting and unlawfully detaining a female victim.
Thank you, sir. Yes, ma'am. I'd like to object first. If I'm under investigation, I thought the investigation came first, and then the arrest came.
Right. As Judge Byrd spoke and laid out the gravity of the situation, a Denver sheriff's deputy named Brady Lovingier stood watch behind Waller. The courtroom was tense, and Waller was shackled in full restraints. Overwhelmed by the moment, Waller turned to ask the judge for further clarification. It was a simple gesture, but it turned into the most dramatic courtroom moment ever. Deputy Lovingier placed a hand on Waller's back and claimed he was merely guiding Waller to sign paperwork with the clerk. Waller didn't like that, so he faced the deputy and asked why he would do that. That's when things took a turn for the worse. In one brutal motion, Deputy Lovingier grabbed Waller by his uniform and the chain binding his belly. Without warning, he slammed Waller's face into the metal window frame that lined the courtroom. The sound of the impact echoed through the room.
But they have 3 days. Get on your feet. You don't turn on me. Roller, this is what you know. Get on your feet. Get on your feet. Where's the taser? Get on your feet. Get on your feet.
Waller stumbled back as if he'd just been the unfortunate star of a blooper reel. His bleeding head struck the frame with such intensity that he crumpled to the floor. His teeth were shattered from the impact, and blood began to pool beneath him. Momentarily, Waller was dragged into the hallway by the deputies. As they pulled him away, he cried out in pain. Judge Doris Byrd had witnessed the entire incident and was horrified by what she had seen. The use of force was not just excessive, it was shocking. She acted swiftly and filed a grievance against Deputy Lovingier with the Denver Department of Public Safety. An investigation was launched to scrutinize every detail of the deputy's actions. Later, Lovingier's use of force was deemed excessive, unjustified, and entirely avoidable. As a consequence, Deputy Lovingier was suspended for 30 days by the city of Denver. But for Anthony Waller, the incident was far from over. He pursued legal action and filed a civil suit against both Lovingier and the city. The jury ruled in Waller's favor and acknowledged that his constitutional rights had been violated by the excessive force used against him. Waller was awarded $50,000 in damages. Despite the abuse he suffered, Waller still had to face the original charges that had brought him to court that day. He was found guilty of third-degree assault and sentenced to 2 years in county jail. As Waller faced his downfall, miles away in Ohio, another cop was about to face the consequences of his actions. But before diving in, a quick like would be greatly appreciated. Now let's jump right in. In Pike County, Ohio, a courtroom sat in tense silence. Awaiting his fate, the once respected sheriff, Charlie Reeder, stood before Judge Patricia Cosgrove. Reeder had served the community for years, but now he faced charges that shattered his career. He had pleaded guilty to theft in office and tampering with evidence. Reeder had stolen about $5,000, money that had been seized during other investigations. His reason? A gambling addiction that spiraled out of control.
As a sheriff of Ohio, I shed, excuse me, I shed bad light on the office of sheriff.
Originally, Reeder was up against 18 charges, but in a bid to lessen his punishment, he changed his plea to guilty. The judge could sentence him to up to 8 years in prison, but he begged for community service instead of prison and cited his desire to be present for his family during important life events.
I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. That day, within minutes, everything that I'd worked for professionally and honorably for 25 years was stripped of me, with nobody to blame but myself. My staff and I had united with the community and had a partnership and trust. And they truly believed in us as a unit, as a whole, and I betrayed that trust. If I could go back and change it, I would 1,000,000 times. Ever did I imagine myself on the defense side of this courtroom that I've spent 25 years of my life in this county in law enforcement. As the sheriff, I gave my staff in this community all of me. Every ounce of my being. There's nothing left for me to give or to take from me other than my freedom.
However, Judge Cosgrove was not moved by his plea. She questioned Reeder about his motives and why he took the money. Reeder claimed that the money was taken from drug dealers who had preyed on the poor in the county.
I have a couple of questions for you. The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
I took the money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did. When schools had cheerleading or pee-wee that had car washes and such, I would have our cruisers taken down there. My men and women did not make good money, so some of them would give them $2, $5. I took money from that and I provided it to those people. Now I replaced it in time.
He argued that he used much of it to support local charities. Clearly, the judge knew there was more to the story.
The money was not in the safe the day that they came and they did the search warrant in my office. 3 days prior to that, which the state has not included, I had knowledge from my secretary, Kelly Sanders, that the security company was coming into my office and that office was going to be open to anyone. I removed those monies from that safe and I put it in the back of the F-250 that I drove. Search
I'm
for it.
sorry, and it would be safer in the lockbox in your car than it would be in a safe?
In an open office?
Which only you have and a few other people have the combination?
Well, ma'am, no one should have had the combination but me. And it strikes me odd that Lieutenant Burchett at the time would make a statement to the state that he'd never seen the accordion file that I provided the state. I did so only on the direction of Chief Michael Spirits, who'd worked for the state at the time, who asked me if I had a comprehensive list of all monies that was in that safe, and I did not. Due to the prior sheriff, when there was an officer-involved shooting that involved his brother, that sheriff resigned, and I took over that office. When I swore him in as a special deputy, he left 2 black marks leaving that office. He handed me the keys. He never did an inventory of the safe, never provided any paperwork of what was in that safe, the money in that safe, or anything. I find it odd that in their search warrant, their confidential informant tells them everything to do with my office, where the safe is, that I have members of my staff telling them that they have never seen anything like that in my safe, which would only be suspect to the fact that they had gained entry into my office and into my safe to have that information to provide to the state. I did what Chief Spirits asked me to do. I organized and made a list of every envelope and every dollar that was in that safe, including the name of the defendant, the date that it was taken, and provided to the state at my attorney's office, to the point that I had to lend my knife to them to open these packages.
Evidence showed that Reeder had a significant gambling debt, and his actions had betrayed the trust of the community.
From the PSI, the video shows on different dates officers counting out money. In one instance, yourself coming to $7,000, for instance, and then turning it over, and there was like $600 short.
And ma'am, Your Honor, I advised my attorney I would take a stipulated polygraph on the $1,000 that I provided on that particular case, that the state now has a cashier's check for $1,000 for State versus Carter. At that scene on Rainbow Trail Road, I was with Lieutenant Burchett. It was videotaped. It was videotaped of Mr. Carter opening a locked door. There's a videotape that exists. Opening a locked door so we could prove that that door was locked and that Mr. Carter had a key. We entered that. It was being videotaped by Lieutenant Burchett. Mr. Carter pointed out where those funds were. They were in some sort of little container, if I remember correctly. They were pulled from that container and counted. They were taken to the back of that same F-250 and placed in the same lockbox in that F-250, where Mr. Carter got in the front passenger side of my truck with me. Lieutenant Burchett followed me in his vehicle directly to the office without stopping. We got to the office. I provided Lieutenant Burchett with the entirety of those funds. So where the $1,000 mistake comes in, I have no idea whether it was accounting error. I have no idea, but I would agree to a stipulated polygraph.
With a stern voice, Judge Cosgrove spoke about the gravity of Reeder's actions. His conduct had mocked the sacrifices of his fellow officers, who faced the same pressures without resorting to crime.
Directly to the office without stopping. We got to the office. I provided Lieutenant Burchett with the entirety of those funds. So where the $1,000 mistake comes in, I have no idea whether it was accounting error. I have no idea, but I would agree to a stipulated polygraph.
But you pled guilty.
I did, ma'am. Yes, Your Honor. And you're asking me, and I'm giving you the explanation. And I have paid the restitution.
I understand you've given, yes, your attorney the
But
full
that particular case,
restitution that was due and owing in excess of $4,000.
$4,850, Your Honor.
That's been done today. All right, I want to go back to, all right, in the PSI, the pre-sentence investigation, it indicates what you're saying here as to why you claim you used the money for various charitable community things. And then, but the PSI officer notes that there's no documentation that you used it for those things.
Right, I did not document those
Okay.
things.
In the end, Reeder was sentenced to 6.5 years, but due to concurrent sentences, he would serve only 3 years in prison. The former sheriff was also barred from holding any public office in Ohio, and his career as a peace officer was over.
Now, the thrust of some of the letters, especially from Miss Kraft, the licensed social worker.
Yes, ma'am.
Who didn't start to see until March 2019. It talks about the stress from all these cases, all these criminal cases, the Roden murders and whatever. Did you ever tell your counselors about stealing from the evidence envelopes?
Yes, we discussed that.
I'm sure there was a lot of stress and sleepless nights you had in terms of your post-traumatic stress syndrome or your anxiety caused by the fact that you opened up these envelopes and took money that didn't belong to you.
Yes, Your Honor. I was being treated since 2013 for those conditions, and it progressively got worse.
Well,
Now,
it got worse during the time period in which these offenses occurred, and in 2016, starting the investigation of rodent homicides. But I wanted to ask you that because
As Reeder's reputation fell apart due to his greed, in another case far from Ohio, a routine patrol in Kentucky spiraled into a courtroom drama fueled by a different kind of betrayal. On the evening of August 21, 2020, Officer Shannon Oliver was on patrol in Eddyville, Kentucky. It was just another night, routine and uneventful, until he heard something unusual. Driving northbound on Highway 93, he passed by a car wash and noticed a man standing by the side of the building. He was urinating openly in public. The man, later identified as Raymond Fernandez, quickly got back into his vehicle and drove away.
I was traveling northbound on 93 South coming into town. I was passing the car wash, which, as I'm sure probably most of you know, is tore down now. As I was passing the car wash, I noticed that there was a vehicle parked off to the side. As I continued to drive by, I noticed that there was a male standing outside of the car wash, and he was urinating on the side of the building. So I drove to the next entrance, turned around in the parking lot so I could go back and speak with the individual. As I was doing that, I noticed that that vehicle was coming out of the car wash and made a left turn onto 93 South to the stoplights. Then made a left turn westbound onto 62 where I conducted a traffic stop. When I approached the vehicle, that's when I spoke with Mr. Fernandez.
Officer Oliver turned his patrol car around and decided to follow him. He wasn't after a traffic violation, but rather to address the public urination. When Fernandez made a left turn onto Highway 62, he activated his lights and pulled him over. As he approached the vehicle, the situation took a darker turn. The smell of alcohol hit him.
So then you said you saw the gentleman pull out from the car wash and head towards 62.
Correct.
If you would, pick up on your testimony from there about when you encountered Mr. Fernandez.
Well, I conducted the traffic stop on 62 West, approached the driver's side. Spoke with Mr. Fernandez, and while I was speaking with him, I could smell alcohol coming from the vehicle. While I was asking for license information, insurance, I noticed that his speech seemed to be a little bit slurred. I asked him to exit the vehicle so I could conduct some field sobriety tests. First test that I conducted was I attempted to conduct the horizontal gaze nystagmus, which requires an individual to not move their head back and forth as I conduct an eye test. And what we're trying to see is nystagmus, which is an involuntary twitching of the eyes if somebody's under the influence of alcohol. While I was attempting to do that, I wasn't able to complete the test because Mr. Fernandez continued to move his head back and forth. So we moved on to another test, which was a one-leg stand, which basically just requires a person stand on one leg with their arms down at their side and count out loud. During that test, Mr. Fernandez was using his arms for balance to keep from putting his foot down.
He asked Fernandez to step out of the vehicle. The tests he conducted next were telling. According to the officer, every indicator pointed to the fact that Fernandez was under the influence. Fernandez was arrested on the spot and taken to the Lyon County Jail.
We also did the walk and turn, which basically has the individual walk heel to toe as they're counting out loud. When Mr. Fernandez started that test, he lost his balance at the first step. After we completed the test, and based on everything that I had seen, I didn't feel comfortable letting Mr. Fernandez drive at that point. I felt like that he was a danger to himself and the others on the road if I let him leave, so he was placed under arrest, transported over to Lyon County Jail.
There, he was asked to take a breathalyzer test, but he refused. Despite his claims of only having a couple of drinks, it was clear he was too impaired to drive.
Once we're there, I'm required to read what's called an implied consent that will basically explain everything as far as the intoxilizer. Mr. Fernandez had stated to me that he had only had a couple of beers that night. I told him that if he had only had a couple of beers, then he would be legal to drive. Your alcohol level wouldn't be high enough to be over an 08. But I also told him that if he had more to drink, that the intoxilizer would show that. So he was read the implied consent. He then refused the breath test. And then at that point, he was picked up by the jailer and transported.
In court, Officer Oliver's testimony was straightforward. He detailed the events of that night with clarity, but on the other hand, the defense lawyer wasn't done yet. He challenged the officer's recollection and assessment of a field sobriety test administered to Mr. Fernandez.
The agency that puts out the book is called the National Highway Traffic and Safety Administration.
Yes.
Does that ring a bell?
Yes.
Okay. Shorthand, they call it NHTSA, NHTSA. So, NHTSA also puts out several follow-up trainings. Have you completed any of those since 2007 with regards to DUI detection and enforcement? Any refresher courses?
We do the training with the intoxilizer every 2 years where we certify on that. The only required training that we have is just what we complete there at the CAT Training Academy.
Okay, let's back up just for a minute. So the training you just mentioned, the training that you redo every 2 years, that only has to do with the intoxilizer machine, correct?
Yes.
That's just how to operate it, make sure that you're certified, you're up to date on all the snuff.
Yes.
Right?
Yes.
Has nothing to do with going on the street and conducting field sobriety tests.
No.
Correct?
Correct.
Okay.
When asked how long Mr. Fernandez was required to keep his foot raised, Officer Oliver estimated it to be about 30 seconds, which he counted in his head. Despite the demonstration, Officer Oliver stood by his observation that Mr. Fernandez showed only minor signs of imbalance. The defense then shifted to the walk and turn test. Officer Oliver couldn't recall the exact number of clues he was trained to look for, but conceded that Mr. Fernandez exhibited only one clue, using his arms for balance. The defense attorney argued that, according to standardized field sobriety test guidelines, one clue was not enough to indicate impairment. However, Officer Oliver maintained that his experience with different individuals led him to believe Mr. Fernandez was under the influence.
You did not see Mr. Fernandez having bloodshot eyes in this case, correct?
Not that I recall, no.
Another indicator is glassy eyes, right?
Yes.
You did not see Mr. Fernandez having glassy eyes.
Not that I recall, no.
Otherwise, you would have written it down, wouldn't you?
Yeah.
Another indicator is having a flushed face.
It can be.
Mr. Fernandez did not have a flushed face on the night of August 21st, 2020.
Not that I recall, no.
Otherwise, you would write it down, right?
Yeah.
Now, these three particular indicators, NHTSA explains is, please stop me if I'm incorrect and if you don't remember from your training, because alcohol makes the cells dilate, it reddens the skins and makes the person feel warm. Do you remember that from your training?
During our training, they may mention multiple things like that, but from my experience in dealing with hundreds of individuals being under the influence, you get different signs from everyone. So everyone may not have the same reactions when they're under the influence.
Which, please clarify for me because I'm a little confused. I think you testified to the one-leg stand after, but in your citation there, you have the walk and turn next and then the one-leg stand, so which is it?
I believe we may have did the one-leg stand next.
So the one-leg stand was second after the horizontal gaze and step.
I believe so.
If you don't remember, it's okay to say, I don't remember.
I believe that that's the order that we went in. Was
You
one-leg stand.
believe, but you don't know for certain.
I'm pretty certain.
You're pretty certain. Okay. So on the one-leg stand, how many clues are there?
We're basically just looking to see anyone that keeps their arms down their side. They're given instruction to raise their foot, either foot of their choice approximately 6 inches off the ground, toe pointed out, and they're to count out loud. We look for approximately 30 seconds. And basically just looking to see if they can follow those instructions.
Are you aware that there is a standardized National Highway Traffic and Safety Administration manual that you learned from in 2007 and 2008 that looks for exactly 4 clues? Do you not remember those clues?
Naming them specifically, I can't name them specifically from the book. I give instruction to the test, and what clues that they show after taking that test is what I document.
But your testimony here today is you do not have them by memory. You don't remember
I
the
don't
clues.
have them specifically from the book by memory, no.
Okay.
Doesn't this feel like something straight out of Better Call Saul? From this point on, the cross-examination took a turn for the intense, especially when the defense presented a computer-assisted dispatch report into the mix. It showed that Deputy Seth Poole was allegedly on scene at the same time as Officer Oliver, a point the officer could not explain. He insisted that he had conducted the traffic stop alone and had no recollection of Deputy Poole being there during the initial investigation.
I'd like for you to clarify something for me, if you don't mind. We're in possession of some evidence from the prosecution that we received early on in the litigation. It is a CAD detail. Do you know what a CAD detail is?
Yeah.
It's a computer-assisted dispatch detail report, right?
Yes.
And the CAD lists the dispatch agent over at dispatch headquarters. They're in front of a computer. They sit on with a little headset, right? And they do the 911, what's your emergency routine, right?
Yes.
And then they radio in officers. We need assistance with this situation at this location and such. We need some unit here and there, and so on and so forth, right?
Yes.
Okay. Well, and I apologize, I only brought one copy because I was not expecting to use it today. There is a notation, and you're more than welcome to take a look at it if I may approach, Your Honor. So you may clarify who is Mr. Seth Poole with the Lyon County Sheriff's Office that was dispatched en route and on site at the exact same time that you were at that location.
He works with he's a deputy with the Sheriff's Department. I don't know. I don't know why it was catted that he was on scene there, because when we were conducting this investigation, he wasn't there. So I don't know what the situation is with that. I can't say what the dispatchers put in their paperwork or whatnot. So I don't know if he showed up after the fact and assisted with the vehicle, possibly. I don't know.
If I may approach, Your Honor. And like I said, I apologize. I would have, I just didn't expect to use this. I would have had another copy, but please correct me if I'm wrong. The dispatch time for Mr. Seth Poole with the Lyon County Sheriff's Office says 21st of August 20 at military time 21:26:17. Does that look right?
That he was dispatched en route at 21:26 the same time, and then on scene at 21:26. I mean,
about a second apart.
Yeah, it doesn't really make any sense. I don't know why.
After the arrest, Officer Oliver handed over Mr. Fernandez's vehicle to his wife, who had been a passenger at the time. However, he failed to administer a sobriety test on her. This oversight was recorded in the computer-assisted dispatch report. Now, this detail has come back to haunt the officer, especially since he had previously claimed ignorance about what happened to the vehicle.
For the duration of the night, let's say from 9:26 until the arrest was made, you have no recollection, you don't remember whether or not Deputy Poole was with you or not.
When I conducted the traffic stop, he was not with me. If he showed up at a later point to deal with the vehicle, sometimes we do that. If somebody needs to stand by with a vehicle or something, then we do that. And if that was the case, it may have happened. I don't recall.
You don't recall. Okay, that's what I was looking for. I'm not asking you to speculate. I'm asking you a question of whether you saw, heard, smelled Deputy Papul. Was he there or not there? What I'm hearing you say is you don't remember if he was or not. Is that correct?
Right, yeah. I mean,
Okay.
he may have showed up at the end. I don't remember.
You just don't remember?
Yeah.
Okay. But not at 9:26:17, as
Not
the
when I
CAD detail
initially
says.
conducted the traffic stop, because I was on patrol and saw the vehicle and stopped it there, so, I mean, he wasn't with me.
The final blow came when Officer Oliver admitted that people just exhibit signs of intoxication differently. After considering the officer's testimony and the defense's arguments, the judge declared a mistrial, citing concerns about the officer's credibility and the handling of the case. The jury was dismissed, and the case was set to be retried, leaving a cloud of doubt over the initial investigation and the officer's testimony.
Your Honor, since I'm asking about a completely different witness, I'm not asking about my client. I think that does not open the door whatsoever.
How is that relevant?
Well, because if the officer did not conduct a full investigation to make sure that the passenger is sober enough to drive the vehicle, it goes to the heart of his credibility as a police officer. If he just thinks, it's my determination, he seems sober, go ahead, that goes to his credibility in front of the jury as a police officer.
If you can keep it in line with credibility, I'll allow it. It's getting very close, though.
Okay, thank you.
With Oliver's integrity questioned in court, last up, we have a former lawman who ended up pissing off the judge by questioning the very system he once served. On March 8, 2019, 51-year-old Pate, who had recently retired from his position, was arrested for his second DUI. The crash had injured another driver. This wasn't his first brush with trouble. Just an hour before his arrest, an officer had stopped him but let him go.
Commonwealth of Kentucky versus Jerome T. Pate. We're here this afternoon. Initially, it was set as a pretrial conference that was continued from a January pretrial conference, the purpose of which was to further address pending motions, including motion to transfer venue, and also then to get this matter set for trial. The court has subsequently been advised that the attorneys have negotiated a resolution of this case on guilty plea.
Pate's legal battle was complex. He faced 9 serious charges: first-degree assault, DUI, 4 counts of wanton endangerment, first- and third-degree criminal mischief, and leaving the scene of an accident. Special Judge Crocker and Prosecutor Blake Chambers were handling the case. Before the hearing, Pate had expressed his willingness to take a plea deal: 75 days in jail, with credit for time served. However, his resolve wavered as the courtroom proceedings unfolded.
At this time, is it your desire to change your plea from not guilty to guilty? That is a yes or no answer, sir. If it is your intention to change your plea from not guilty to guilty, then I will take your plea, and certainly you'll have an opportunity to make any statement that you want to make. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
After the recess, Pate admitted he had intended to plead guilty, but was struggling with the decision. His words were heavy with the burden of his past. He talked about his 25 years in law enforcement and how he had never charged anyone with felonies in cases similar to his own. He felt the charges were excessive and that he was being pushed into a corner. Pate's speech grew more emotional. He acknowledged his wrongdoing and admitted that his bad decisions had led to this moment.
It's difficult for me to enter a guilty plea for a lot of reasons, but I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. I do absolutely feel like that because of my bad decisions, that this whole case took it's difficult for me to plead guilty.
According to Pate, the prosecutor had misrepresented facts to the grand jury. He spoke of feeling bullied and pressured to accept a plea deal that didn't feel just.
But I absolutely think I was indicted. That prosecutor said, got my indictment, I will jump out. Then I made an offer based on those indictments on a Monday. We sent an email back to Mr. Chambers' office to not accept, and 2 days later I'm indicted for assault first, and when if you're found guilty, you spend 85%. This was never an assault first case. Should have never been an assault first case, but it became that, and it became that to push me in a direction to take a plea. I'm willing to take a plea, but I now understand how some people feel. I've defended the court system many, many times, and still do, but I feel like I'm being very much bullied into doing something that's not right. Now the gamble is big. Mr. Chambers wants to go to trial and say, well, let me tell you this, that, and the other, then I'm risking leaving my family, which I did that March 8th when I drank and drove. Thank God I didn't kill anybody. But I want this court to know, I want the people to know, I want the public to know that Todd Pate holds himself responsible for everything that he did.
However, Judge Crocker was not swayed by his arguments. After listening to Pate's long-winded explanation, she brought the court back to the matter at hand. The court had executed plea documents. Despite his protest, Pate had agreed to them, and he went to jail. Judge Crocker ordered Pate into custody and revoked his bond. Pate was taken into custody to be held at the Breckinridge County Jail. At a later hearing, he was ordered to serve 75 days in jail.
I think we are back, Mr. Pate, and probably should have stayed in the place where we started. Again, I wanted to give you an opportunity to have further discussions with your attorney. But I think no, you don't have.
I'm sorry for.
What I need to, I think we're back to where we were before. Is it your intention today to enter this guilty plea? And I think we're at a yes or no place at that point.
Can I say one more thing? I think everybody in this room wants this over with. If I could address Blake, I hope you learned from this case I'm not mad at you. I'm not at any way upset.
Mr. Pate, we have reached that point now.
Okay.
This is either a yes or no. Are you going to enter your plea or not? And so let me tell you where I think we are today, is that we have executed plea documents. Whether or not Mr. Pate has the right to withdraw his plea now that he's executed those plea documents remain to be seen. And at this juncture, this court could not, based on these preliminary statements that Mr. Pate has made, make a finding that this plea is knowingly, voluntarily, and intelligently made. Where I think we are today is that on the one hand, the Commonwealth can, if chooses to do so, to enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He's going to be taken into custody today. We will come back for further hearing as to whether or not to go forward with this plea or to set this case for trial. And I will look at additional conditions with respect to his bond at that time. He's going to be held without bond. Based on, at least at this juncture, there having been an executed plea where he was to serve 75 days with credit served. There will not be any arrangements made with respect to house him in Grayson County or anywhere else, that he will be taken into the custody and housed in the Breckinridge County Jail. And at that point in time, if the Breckinridge County jailer wants to make arrangements with another jailer to house him, he can. And then what we will do is we will look at coming back as soon as your respective schedules will permit in order to hear argument on whether this case should proceed forward on resolution of a plea or whether it should proceed forward on resolution for trial, and if by trial, then where that case should be tried. But at this point, we've got a fully executed plea document that provided in pertinent part that he was to serve 75 days in jail, and he's going into jail today.
The hearing ended with a clear message. The law was not a game to be played. That's it for today. YouTube algorithm thinks you will like this video the best. Watch and find out if it's right.